welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is James Stern, Associate Professor of Law at William & Mary Law School. We will discuss his article, Intellectual Property and the Myth of Non-Rivalry. So James, I just got to say, I really thought this paper was fantastic and really provocative because you question a lot of really fundamental assumptions that are kind of taken for granted among a lot of United States intellectual property law scholars, really about the kind of structural features of the justification of intellectual property law. So I was wondering if you could kind of take a step back for a moment and just explain to listeners sort of what those assumptions are, sort of how what's kind of the prevailing view of how U.S. IP law scholars think about the structure and justification of intellectual property law in relation to property law more generally.
Sure, thanks, and thanks also for having me. Well, the basic idea is this, that in the first place, there's something that's very odd about the whole idea of intellectual property, that there's something very different about ideas and information compared to physical things. So with physical things, if you're sitting in a chair, it's not possible for someone else to be sitting in it at the same time, at least, let's say with the same level of comfort. Whereas with ideas and information, that's not true. That two people can use the same, can think the same thoughts at the same time. Two people can sing the same song. People can take the same kind of medical treatment. Whatever it is, the use of ideas and information by one person doesn't prevent another person from doing the same thing. And as a result, there's something that's very strange about the very idea of intellectual property, because the use of ideas and information doesn't preclude use by others the way the use of physical goods precludes use by others. So that's the basic idea that's in the background. This is often filtered through a kind of somewhat sophisticated economic modeling but that's the basic teaching at the heart of it. As a result, the idea is that we don't need intellectual property in the ordinary sense that we do property in physical goods, because we don't have to decide from an economic standpoint who's the highest valuing user, and we don't have to sort of figure out what's the most efficient way to allocate this, because uses aren't mutually exclusive. And as a result, the justification for intellectual property, if there is any in the predominant theory in the United States, is a kind of incentive theory. The only reason we do this, the only reason we grant IP rights, is because we think that the benefits of doing so will encourage people to produce IP goods. It provides a kind of an incentive, or basically a subsidy or a bounty, kind of like offering an honorarium or a prize in exchange for coming up with the things. It's a kind of motivation theory. But if we weren't concerned about motivation, there'd be no reason to do it.
Yeah. So, one of the ways you talk about it in your paper is like the difference between static and dynamic efficiency, right? So to put it in sort of economic terms, that when we think about scarce goods or physical goods, we have to think about who's going to get them. But when it comes to things that we refer to as intellectual property, because it seems like, at least in some kind of, in some sense, they aren't used up by people using them. We're thinking more about how to produce more in the future.
Yeah, exactly. When you've got a thing that can only be used by one person, from a kind of loose utilitarian standpoint, what you want to do is make sure that it goes to the person who values it the most, at least irrespective of distributive concerns. If you're trying to make the most out of stuff and avoid waste, you want to see who it's going to benefit the most. With ideas and information, as the received theory has it, well, you don't have to do that. You're not put to that choice. And so the efficient distribution of ideas and information is that anyone who wants it gets it, because you can share it in the way that, you could never do that with, courtside seats at a Lakers game. The efficient allocation isn't everyone who wants it gets it, because the perimeter is fixed and you can only have so many people.
Right. So what kind of policy lessons are traditionally drawn from that kind of observation? I mean, is there a way of kind of characterizing the policy assumptions or prescriptions that tend to grow out of the idea that we should be only concerned about dynamic or kind of efficiency or future production when it comes to intellectual property?
Well, there are a bunch of different things that grow out of it. Let me just kind of cite two in particular. One is just a general attitude. It's not a doctrinal teaching, but it affects all doctrines. And that's the attitude that we should be suspicious of intellectual property, that we should view the whole enterprise as kind of fundamentally suspect, and maybe in terms of the public-private distinction, clearly on the public side of the line, because what this is a kind of government grant, revocable at will, properly speaking, that just seeks to achieve a certain kind of end. There's no intrinsic philosophical grounding to it. There's nothing to be achieved in terms of IP itself. It's just a means to an end, and one that comes at considerable costs that we need to be careful at all times, are not exceeding the benefits of the enterprise. So that's one part of it that affects everything. A second piece of it is what I would call it. I view this as kind of circular. The view that we shouldn't allow IP rights holders' interests in suppressing the use of idea and information into the system, because ideas and information are non-rivalrous. So if you are at the extreme end of things, Howard Hughes or J.D. Salinger, and you want to keep your stuff from the public eye, that's not an appropriate use of copyright law, because that's not what copyright law is. Therefore, copyright law is exclusively a system of incentives and encouragement. It doesn't, in any sense, recognize the individual creators, any kind of rights that person might have to control the output of their creative processes.
Yeah, and it really seems to me like there's this core assumption among a lot of intellectual property scholars that because intellectual property of traditionally patents and copyrights, but other things as well aren't used up when people consume them, that we don't have these allocative concerns. They're non-rival, so we don't have to worry about who gets them. Anyone who wants to ought to be able to consume them, except for providing an incentive. And you question that assumption. So maybe you could talk a little bit about why you think that way of looking at knowledge goods is not correct.
Well, I come at it. I was fortunate to come at these things not knowing anything about anything, and I worry that if I'd known more about both either property law or intellectual property law, I would never have reached the conclusions that I reached. Although I stand by them now, that I've learned a great deal more. But the my basic argument is this: the incompatibility of two particular ways of using something is representative of a larger phenomenon, but it doesn't exhaust it. And the larger phenomenon is resource conflict. It's not simply that, the reason we have property rights and stuff is not just because two people can't use the same thing at the same time, but because people have disagreements about the disposition of different goods in the world, what's going to be done with them. And when you view, and so, one reason people might have disagreement is because they both want to use the same thing, in the same way, and they both can't do it. But that's not the only reason by far. Sometimes people just have reasons why they don't want someone else to do something with a particular thing. But it's not that unless you define what they're themselves doing as not having someone else do it, it's not that they're trying to use it themselves actively. So think of historical preservation or land conservation or anything like that, situations where people just don't want something done. And if that's what's going on, and incompatible use is only a subset that gives rise to that problem, well, then that happens all the time with IP. That happens, and not just IP. Let me back up a bit and say that happens all the time with information goods. That is that is the law of privacy, which is not even a singular thing. There are many laws of privacy in different contexts, from trade secrets to revenge porn to you name it. All these different to libel and so on. There are all kinds of situations in which people don't want information used in particular ways that others do want to use them. And if that's right, then the basic problem at the heart of property remains. That's the kind of common sense account of it. There's an economic view too, which is that the use of ideas and information can impose external costs on others, including externalities. That is to say, costs that others don't take into account. So, the irony for me is like, you have EFF, the Electronic Freedom Foundation, on the one hand, that's quite critical of IP, but on the other hand, very positive on privacy rights. And that's fine. That may be perfectly conceivable and coherent, but what doesn't work is to say, well, look, those two things don't need some kind of reconciliation. Those two things don't interact with each other, because they plainly do. You might well think that, and in fact, people do argue that privacy rights are a kind of IP, and that what's at stake here is conflict about information and who gets to control particular bits of information.
So one of the things I thought was really provocative and frankly convincing about your article was the way you really point out that if we're serious about being utilitarian about these kinds of policy choices, then utility can be produced in a lot of different ways. And there's sort of this assumption baked into a lot of IP scholarship that more consumption always increases utility. And I thought a really interesting move that you made was to point out that that's just not empirically true. And that as an empirical matter, right, it's sort of an open question when certain policy choices are going to increase or decrease utility, and that there's no sort of obvious, one-way switch sort of answer.
And above all, the empirical questions are really hard. I mean, admittedly, that's a standard move in legal scholarship, to say, when it's empirical, who knows what's going on out there, but it's standard for a reason. And I feel kind of compelled to make it. And the reason partly is that there are, it's not just, how do we know the sky is blue, but there are lots of areas where we do seem committed to the idea that people should be able to restrict the flow of information. I don't want you reading my emails right now. I mean, actually, I don't mind, but so that's a big thing. And so the question is how you go about measuring this, because there are these assumptions that are made. It's actually, I'm a little bit idiosyncratic in the IP realm as being kind of a Luddite and kind of checked out from pop culture. And when I say checked out, I mean skeptical of. So, I look at these things from a kind of different perspective. Material progress I absolutely believe in. I'm not, I have rather more mixed feelings about the recording industry, which crowds out a lot of things that I like. So it kind of, in that sense, it kind of makes it easier to see what's going on.
Yeah. Well, there was one line that really struck me where your peculiar voice came through in the paper, where you said regarding various innovations that it seems a safe bet that a good number would rather the human race had never come up with such novelties as landmines, cigarettes, cargo shorts, jet skis, genetically modified foods, anabolic steroids, robocallers, date rape drugs, subwoofers, Ponzi schemes, and crystal meth, which didn't strike me as an entirely arbitrary list of things.
Well, I was going for broad consensus. There are lots of things that people that are maybe a little bit more some people like and some people don't like, but I was going for the strong ones, like
like cargo shorts.
All right, I was throwing that in. I stopped short of cargo jorts, but
I thought it was very
nuclear proliferation. We don't want that to spread. Well, the classic metaphor of Jefferson's taper: he who receives an idea from me receives instruction without lessening mine, as he who lights his taper at mine receives light without darkening me. Well, when that's how to make an atom bomb, actually, I'm not sure the human race is necessarily advanced when that knowledge spreads. Now, that's a deep question. That's a hard question. It might well be that patent law causes the annihilation of the human species. I mean, that's not where I am, but it is, it's possible. And by the way, patent law now excludes the patentability of atomic weapons technology. It wants to withdraw its incentive effects from that. But there are all kinds of things. Maybe we will all be serving our robot overlords in 50 years' time. That maybe all this innovation will have turned out to be a bad thing. I think as scholars, we have to be, we have to recognize that's at least a conceptual possibility. And by recognizing it as a conceptual possibility, it suggests a lot of things about the nature of IP law now.
So one thing I really liked as well about the paper was the way you sort of pointed out how the framework for kind of conventional justifications for intellectual property, sort of the conventional, economic utilitarian story, presents itself as kind of an empirical story and a normatively neutral one, but that ultimately it's kind of based in normative assumptions. I was wondering if you could kind of pick that out a little bit and explain why you think that is.
Yeah, and the first thing I'd say is, we should all be wary when what are fundamentally empirical claims can be resolved without leaving our desks or offices or whatever, or in the shower. And that's the nature of the claim about non-rivalry, right? The claim that, in a sense, the use of ideas and information is costless. To say that this is so, that not to engage in excessive flattery of my host, but it's kind of ipse dixit to say that the costs of the use of ideas and information is zero in all cases. As such, we should be suspicious of that a seemingly empirical claim reduces itself to that. And kind of more generally, I think there's something that's amiss in the use of the economic terminology. I don't have a degree or anything like that in economics, but I've gone deeply into the economic literature, and I sort of came to the conclusion that a lot of the materials there are abused and used to support things that they weren't originally meant to do. And some of that is true. It's, I wanted to say it's just the IP scholars who are doing it. It's just the law profs. That would make it easier. I fear, unfortunately, there are prominent economists who do the same thing. But that the public goods concept, you might say, there are at least three different problems that are identified and potentially march under the banner of public goods. And they get kind of conflated and used in a way to kind of do stuff in a conceptual way that's fundamentally empirical. But at the end of the day, the empirical point is just that if what we're saying is that the use by one more person of some information good really imposes no costs on other people, that's an empirical claim. And a moment's examination of the world shows that that is not true, that we deeply care about what people do with information goods. And there's kind of two other things that I'd add to that are kind of, I don't know, mind-blowing, but like get to the kind of deepest part of things. One of them has to do with just the nature of what things are. That the way we carve up the world into different things, this is kind of a Henry Smith point, maybe, or Henry Smith plus Duncan Kennedy. That's kind of arbitrary. And, if you think about something like gun control regulation, we think of that as the regulatory side of things, but there's no, reason in the nature of reality why we couldn't say, well, that's rights over guns, which is kind of a thing, a race, as though, the FDA has, jurisdiction over, food, drugs, and cosmetics, or whatever. We could say like that's sort of a thing that they control. And if you think about it that way, like the rivalrousness or, potential for conflict with technologies is just totally massive. So in that sense, like the way we've chosen to define things sort of, builds in or reflects our view of what is conflict producing and what isn't. I had a second point, but it eludes me at the moment.
So the reading your paper, what you've said so far were all points that I found like really insightful and also really compelling. There was one thing that kind of was nagging at me a little bit, and I wanted to kind of ask you about it and see what your thoughts were and how you would respond. So, when you make the shift in your paper from talking about like physical scarce property to intellectual property, where scarcity becomes a different kind of question because it has a certain kind of public good quality to it. You point out that, we no longer have to think about allocation, and that we should be effectively, at least as I read it, we should be thinking about sort of the utility consequences on individuals, and the fact that one person's use might conflict with or reduce the amount of utility that somebody gets from the same good. And I think that's true, but I wonder, do we think about property policy and government action in relation to property in the same way with respect to physical property? And if not, is it fair to have like almost like a higher standard for when we think about how we should do property policy when it comes to knowledge goods?
Tell me what do you mean by that?
Well, it seems to me like that. Yeah, I mean, it seems to me that when we think about the allocation of scarce goods, of physical property, we don't typically think about which allocation is going to kind of maximize the enjoyment of consumers. We say, well, we're going to kind of set the bounds of property, and then we're going to more or less rely on quotient allocation for things to find the right distribution. And, we just kind of figured at a certain point the government doesn't really know enough about how to distribute stuff, and that people are better at doing that on their own. And I feel like in the abstract, the point that you're making about intellectual properties is like almost like once you say it, like almost obviously true, right? I mean, like it is just the fact that different uses can cause different amounts of utility from the property. And you do point to some circumstances where we worry about those questions in, like with respect to physical property, like use the analogy or the example of like, parkland, and should it be developed or not developed? And like, we do take that into account, but like, that seems more like an exception than a rule. Normally when it comes to physical property, we just kind of distribute it and say, well, it'll shake itself out on the back end.
Yeah. So, part of what is going on in this paper is just a certain beef that I have in property theory, or an argument among friends, you might say. People I admire a great deal, like Tom Merrill and Henry Smith, have suggest that the reason we have property rights is, in a sense, as a means to an end, or the reason we have the right to exclude in property as a means to an end. That the reason we have that is just to protect the interest in use, but it's a kind of rule-like way of doing that. And critically, they say there's no interest in exclusion per se, and that strikes me as wrong particularly in terms of everyday intuitions about property. So I teach these cases, and I ask my students. I don't know if you do this, but case like not State versus Czech, Jacques versus Steenberg Homes. Sorry, opposite end of the spectrum, where there is a property owner and there's people delivering a mobile home, and they traipse across this couple's farmland. There's no clear damage, but the Wisconsin Supreme Court says this is really bad, and we're going to hit you with a lot of punitives. And my students say that's absolutely right, because you don't get to do that to other people's land when they don't want you to use it. And I say, yeah, but there's no harm. It's the middle of winter. There's no, the compensatory damages here are like zero. So what's wrong with that? This is, in a sense, a non-rivalrous use of land, and people say, "Yeah, but it's theirs. It is what it is, and it's just kind of fundamentally, irreducibly yours, and that's what it means for it to be yours." That instinct is strong, and I don't know what to make of it, because I don't think it always controls, but I also don't think it always yields. I think it has validity within human societies and whatever else. And so, it's just kind of there. And, it strikes me as being, you talk to strong IP people, who strongly believe in copyright or patent or whatever. And they say, well, look, it's mine. You don't just get to, take and pay or take and not pay. Once again, it shows up. So, I think there are limits to which the everyday understanding of property, kind of embeds all that.
So I think a lot of what you were just saying got at this kind of deep observation for me that, what we're doing when we do intellectual property policy is indeed fundamentally normative. And I do get, in a sense, I found the distinction you drew between, kind of ideas around privacy and ideas around sort of like the way that people, value particular uses of physical property, even though they would technically be non-rival, they still don't want those uses to get made. And I wonder if that doesn't imply that the sort of distinctions we make between sort of private information and published information, sort of in a way that you alluded to the distinction that EFF makes, in kind of a broad sense, where they're kind of pro-privacy but skeptical of copyright. I wonder if that isn't just sort of a reflection of a certain kind of normative perspective on kind of what property rights and information should look like.
Well, that's the thing. If I say, if we look at, J.D. Salinger squirreled away in New Hampshire, trying to keep his stuff from the public, or trying to make himself look as flattering as possible, or whatever else, that seems somehow antisocial. If, on the other hand, you're trying to hack into my email to see what I think about something or other, and let's say I'm it's a matter to some extent of public concern, we think that that's kind of creepy for whatever reason. There's a line between these things, and it's hard to put it mildly. in the borderline cases, well, they're really quite borderline. What's the difference? Artistic integrity. I don't want to see my something that I created, or maybe something that someone else created, used or subverted in some particular way. I don't want to see a building that I constructed turned into, repurposed as a kind of postmodern thing where you save the facade, but you put up a glass thing behind it or something like that. What makes that legitimate, illegitimate, or somewhere in between? I think, we don't really have that worked out, but the whole edifice of non-rivalry is predicated on having very easy black and white answers to those questions.
Mm-hmm. Mm-hmm. And because of that, it really struck me that, part of what I can't shake from the paper is the sense that this sort of this sort of economic language we use to talk about why we supposedly do intellectual property policy in one way and why thinking about intellectual property policy in that way is justified might just be the wrong frame. And that, for example, when we think about things like, what copyright policy should look like, maybe the limiting factors, as you seem to kind of suggest in the paper, ought to be more normative and ought to be based in things closer to like what we talk about when we talk about like First Amendment policy, for example. That it's really about, when do we think that allowing people to limit communications is, normatively acceptable and when isn't it? Not when is it going to produce kind of better utilitarian outcomes?
Yeah, I mean, I think those questions are just very hard, and resolving them is not straightforward. To be the place I've come down at the end of the day is because I've struggled to figure out why I'm wrong. I'm kind of convinced at some level that I am, but nobody has been able to tell me why. Mm. And the place I end up in part is with the conclusion, not that ideas and information are non-rivalrous as a phenomenological description in the way that's ordinarily said, let's say a kind of objective, just a truth about the world, the truth about the nature of things that is true quite apart from anything about the legal system, but mm-hmm. rather that they are non-rivalrous as a matter of stipulation within American intellectual property law. That, leave your rivalries at the door before you come in is kind of the approach to things. And that may well work and be right or all kinds of stuff, but it's totally different from the way we talk about these things now, which is as a kind of, scientific observation about the world, which I think is just kind of not true. So there might be good reasons to say, look, what we're doing in the copyright space is just trying to create an incentive for creators. And we're not, if we're going to do moral rights or protect the integrity of art or all these kinds of things, if we're going to do that, that's a separate track. And if we're going to protect rights of privacy, that's a separate track. You can't use copyright for that. That's perfectly plausible as a legal proposition. I mean, it has to be, that's a debate to be had whether that's what we're going to do. But I think that's ultimately kind of what is really going on, rather than actually an observation about the way things are. Although, obviously, if it's the right thing to do, as presumably people believe, that it has some connection to the way that things are, but it is not a direct description of the way that things are.
Mm-hmm, mm-hmm. So in closing, James, I wonder if you could reflect a little bit on, sort of how you think this alternative frame for thinking about the sort of abstract justification for intellectual property rights ought to inflect policy on the ground, or rather, in some sense, it almost seems like the paper suggests that, policy on the ground is already reflecting a lot of these ideas. And it's actually scholars who are seeing it like through a lens darkly, as it were.
Yeah, there's a bit of both. And I have no normative commitments at the end of this. This is in that sense, I hate to say a kind of deconstructive paper in the sense that I'm just tearing down, not building up. But I hope that I'm saying things that are true that people realize, and that points people in the right direction. But I don't take a position on, I don't have a normative theory generally, let alone one particular to IP. My reaction here is just to say that's not true. And the examples I start with, these rock musicians getting angry about the use of their songs, like that actually is like historically like kind of the origin of this piece. I remember thinking about things like that before I knew anything about IP, and thinking, what's so controversial? That's what property does all the time. It deals with those kinds of conflicts. And, you talked before, you mentioned the idea of scarcity, an insufficient supply of material stuff is scarcity in its most elemental form. But even in primitive societies, people sacrificed animals, their prized goats and heifers and things like that, to the gods, in a way that suggests scarcity isn't the ultimate thing that drives human motivation. What does is people's conception of the way things should be. And to the extent there's a scarcity problem in social relations, the real scarcity problem is that we don't all want the world to be the same way in all particulars. That is to say, what really drives things is human conflict. Material scarceness is a major source of human conflict. But even wealthy societies, and maybe especially wealthy societies, have plenty of opportunities and all sorts of propensities for conflict. And that's sort of the point that I'm going on here. And not just conflict in a niddling way, not just conflict because they're difficult, though that is real, but also conflict because, people have, high aspirations as well as aspirations to get through the day. And that turns up in IP law.
Yeah. Well, thanks a lot, James. I mean, this has been a really, really enlightening conversation. And, the paper really blew me away. I got to say, I mean, it really was, I think, an important corrective observation, and I will definitely be drawing on insights from it in the future.
That's very kind of you. It was the most fun paper I ever wrote. So.
We're here with Alan Arkin, who's one of the stars of the new comedy Fire Sale. Was it difficult getting into your role?
That sounds dirty to me. You don't get into a role. You do it.
What is the title of the movie again?
Fire Sale. Come and see it if you have half a chance.
It's unusual for a major Hollywood actor and director to beg like that. Are you embarrassed?
No, I have a large percentage of the profits.
Fire Sale. It's just plain nuts. Rated PG, parental guidance suggested.